I'm going to try to induce Brian O'Toole. We'll see how that goes. Thank you, Ann. On behalf of the elder law section, it's my honor, my privilege to introduce Brian O'Toole. He's an estate planning and elder law attorney based in Walnut Creek. In addition to providing the occasional seminar on elder law developments, he helps his clients navigate the various legal and financial challenges that come with getting older. As a former GQ model, he enjoys long walks on the beach. His favorite movie is Frozen. And without further ado, let it snow or let it go, Brian O'Toole.
Thank you, Douglas, for a one-of-a-kind introduction. About half of that I prepared. The other half was Doug ad-libbing. I will let the audience decide which half is which. And again, thank you for the elder law section and the bar for helping me get the word out there through this seminar. I like to think that this is one of those areas that everyone knows a little bit, but certainly no one knows everything. But as a lawyer, very often if you put an estate plan together, or if you just are sort of known as the lawyer in your social circle, these are very common issues that pop up, whether it's someone's uncle or aunt or mother or father, or as I'm 45, so increasingly I think, geez, it's going to be my demographic dealing with this stuff pretty soon. So just one of those things that at a minimum is good to know a little bit about. And then certainly as we go through this presentation, if you want to type any of your questions into the chat, I will try to weave those into the presentation itself. It makes it a bit more colorful and interesting when there are questions, so please don't hold back. If you have a particularly detailed question that starts with, my client has a complicated problem, please wait to the end, and we have some time for just question and answers, but a more complicated thing, push that out. But do try to ask any questions as we go along. My joke I usually start with is I'll ask the audience, what's your favorite law show on TV? Or I'll ask attorneys, why did you get into law? There's people like Law and Order, or they wanted to work in corporate law. And this is almost this thing like these sorts of issues pop up at Thanksgiving dinner, and it's sort of just this very humdrum set of issues that enormous numbers of families run into, but it's not always front and center. People get older and they get a little dementia, they get diminished capacity, then there's a slip and fall, then there's all sorts of things that can go wrong. And so really what this seminar today is to give everyone a taste of what elder law is designed to do, and where elder law issues crop up, particularly if you've written a lot of wills and trusts over the years. The cycle of your career, you put all these wills and trusts together, and then as you get older, your clients get older, and people start passing away, people start getting older, and sometimes they get in some pretty tough medical situations. So with that, we'll take a look at just some introductory stuff with Medi-Cal planning. We'll certainly go over sort of the tried and true traditional things you want to take a look at. Then there's some major changes coming around, especially with regard to eligibility, that is frankly going to broaden the number of people that are going to be eligible for Medi-Cal in the next probably 2 months. So we'll sort of talk about that, what those changes are, different benefits programs that are starting to come online, and we'll just kind of go from there. But yeah, without further ado, let me get started here. There we go. All right, so I always try to start with estate plan design. A lot of the time you'll get a phone call and it's, some disaster has happened medically, and your client, is incapacitated, something's wrong. And so the very baseline for me as the estate planning attorney is to make sure I have the right tools in the toolbox. If you like, the estate plan is a bunch of tools analogy. And so the basic idea here is you want to have flexibility in the estate plans that you've designed or that you're updating as life goes on. And so you want to sometimes think about, what is a protective trust and what are protective provisions versus what are flexible provisions, and what are the distinctions between those two. So, the first thing I always look for, if someone comes in, they say, hey, my mom's starting to forget things, she's going to come in. So, I'll be going over the will and the trust with the mom. And, I always look to see, does the agent have the authority to amend or revoke the trust? Or does the agent have the ability to gift assets through a power of attorney? And so those are controlled by your very own probate code. And the bottom line is that an agent cannot amend or revoke a trust unless both the trust and the power of attorney allow that to happen and have the authority to allow that to happen. I always think of it as like a lock and a key, and you have to have the key in the power of attorney inserted into the lock in the trust in order to unlock this thing. And so you need those mirrored provisions in your powers of attorney and in your trust itself. And it's more protective to say only the grantor can amend the trust. But what can happen is, well, then you can't revoke any portion of the trust. You can't amend the trust at all. And likewise for the gifting. Gifting is a very effective and simple way to get from too rich for Medi-Cal to just poor enough for Medi-Cal. So an agent can only gift assets if it specifically says that the agent can do that in the power of attorney. And so that's something you'll often see, either no gifting power, or you'll see the agent may gift assets up to the annual exclusion, which is only $15,000. And that's fine, but those are protective elements. In a Medi-Cal situations, you kind of want to take the child controls off. You want to make sure the agent has authority to make some pretty big financial moves. And it gets back into a lot of the ethical obligation. Your client is typically the elder. It's not the kid who wants to maximize the inheritance. And so you always have to make sure that you know who you represent. You have your representation agreement. You have your service agreement. And it all kind of makes sense with regard to who you represent and whose interests you're looking at. Sorry, I had to turn off my my chat in order to scoot the presentation along. So Ann, if you do see questions that pop up, just poke me, or not figuratively, not literally.
Okay, got it, Brian.
Yeah. So, and then, if you don't have authority or you don't have an estate plan at all, 3,100 petitions can work. If you need to move assets from a couple over to the healthier spouse, you have one spouse, 15409 petitions, conservatorship, those are just the court approach to doing what an estate plan ought to do, in my opinion. But bottom line, by the time you're going to court for all these different things, I'm sure everyone's familiar. I submitted a petition to Alameda in January, and I got my court date in October. So, you don't want your agent, your client paying $10,000 a month in nursing home fees over the course of 10 months, while the courts try to figure out when to schedule your hearing. So, as a general rule, as an elder law attorney, I try to provide flexibility in those documents. For all those litigators out there, you probably go, geez, why would we want to give an agent the authority to gift or to amend and revoke a trust? That's the caution. You have to make sure the right people are in place and that they have sort of the elder's best interests and their wishes in mind to go forward. But yeah, any questions? Are we looking pretty good? All right, we'll move along. So typically what happens is, you say, oh, what's Medi-Cal, what's elder law? You always want to start with what Medicare does for people. And so the bottom line is Medicare is a great program for doctor visits and hospital visits. It's not so great for long-term care, but it's good to kind of have a sense of what Medicare coverage provides, because most of your clients who are considering an elder law strategy are already going to be covered by Medicare. And so if Medicare will do the job, you don't want to launch into a giant Medi-Cal approach, because it's just untimely. But it's good to know what Medicare does. So Medicare is going to cover a patient when they go to the hospital. If that patient is in the hospital for 4 days, the actual rule is 3 days, not including discharge. But it's easier to just say you have to be in there 4 days. You're in there for 4 days, Medicare will cover 100 days of skilled nursing rehab. So that's an important concept. It's not 100 days, period. It's 100 days of rehabilitation. Days 1 through 20, there's no charge to the client, no charge to the patient. Days 21 to 100, you get this copay, which is kind of steep. But for a lot of people, if you get a broken hip, something like that, a broken ankle, you're in there, you get patched up, you're in there for a month, you get discharged, everyone's happy. Sometimes your clients will have supplemental Medicare coverage, and that'll cover that copayment. A big thing that your clients run into is when the nursing home starts getting nervous that they're going to stay long-term. The short of it is that Medicare rehab pays really well for the nursing homes. Long-term Medi-Cal does not. And so as a general rule, the nursing homes are trying to get patients in who are doing rehab and then discharging them once they've gotten better. And that's generally everyone's interests align on that because the client or the patient wants to get out of there. The nursing home wants to get paid for another rehab patient to come in. No one wants to go through Medi-Cal. No one wants to stay at a skilled nursing facility. But the bottom line is that some people just aren't able to return home for one reason or another. It's just not safe. They don't have the support. They don't have the money. And so long-term care becomes an issue, and then how to pay for that becomes an issue. The bottom line, Medicare is only going to cover you for 100 days maximum. And then the rule of thumb is that they can cut you off before that 100 days if they determine that you're no longer rehabilitating, if you become custodial or you plateau. And that's how they sort of start strong-arming your client, the patient out of the nursing home. Oh, Medicare is going to end next week. You need to send us a check for next month's care, which is, $12,000. So people go, oh, we got to get out of here. But if you're in the facility, they can't kick you out just because you transition onto Medi-Cal. And so that's, in terms of a Trojan horse approach. You go to the hospital, you are the Trojan horse. You are exactly the patient that the nursing home wants, which is a Medicare rehab patient. Once you're in the nursing home, if it's going to be a long-term stay, that's when you let them know, hey, we're going to jump onto Medi-Cal. We're working with the lawyer to navigate the Medi-Cal application. So increasingly, the nursing homes have been trying to boot people out earlier and earlier to protect against a long-term stay. And it turned out there was a backlash to that. And so the Jimmo versus Sebelius case basically said that the rule of thumb is incorrect. The actual rule is that if someone's benefiting from any level of nursing care, including just keeping even, or even if they're declining in care, the fact that they're in a skilled nursing facility is helping them maintain some degree of health, that's how you have to determine whether or not you get cut off early. And so bottom line, most nursing homes don't care about that. And even if you challenge their decision about an early termination of Medicare, you can appeal it. Usually you don't win that anyway. But at a minimum, if your client is going to challenge the Medicare early termination, you want to provide the Jimmo v. Sebelius analysis, and provide that. And there's certainly websites that give you like a one-page summary of it. But CMS, the Center for Medical Services with the government, that's the link I provided you there. But any general questions about Medicare coverage or what that does or doesn't do? All right, moving along. So what happens is, your client goes to the hospital. From the hospital, they get transferred to a nursing home. Their Medicare runs out. And then they have to make a decision. Do they want to stay at the nursing home or do they want to go home? If they want to go home, you don't have a Medi-Cal problem generally. You just say, okay, we'll go home, see what we can do. If you're going to stay, then you have to decide, do you want to pay out of pocket or do you want to try to transition onto Medi-Cal benefits? In Medi-Cal benefits, you don't lose Medicare. So you just add Medi-Cal. And so, Medi-Cal can provide long-term care. That's when people think of Medi-Cal and older folks, that's typically what they think of, the long-term care in a skilled nursing facility. However, there's other programs. There's assisted living waiver program. So what the government's trying to do is to provide some Medi-Cal applicants with assisted living support because they don't want to put everyone into long-term care if they don't necessarily need it. So bummer on that is it's a trial program and there's about a 2-year waiting list. So it's not something that's immediately available. And also the assisted living waiver is only available to people with no share of cost Medi-Cal, which means you're basically under $1,500 per month in income. So Social Security, pension, RMD, stuff like that. So the assisted living waiver looks great on paper, but it turns out a lot of people just aren't eligible because their income is too high. And then even if you are eligible, there's a 2-year wait, which may not be helpful or feasible to wait that long. Very interesting thing, the PACE program. So this is something of a new development. The PACE program is it's designed to be this one-stop shop where if someone is Medi-Medi, so they're eligible for Medicare, they're eligible for Medi-Cal, and you have a doctor that says, even though this person's not in a nursing home, they should be in a nursing home. So you need to have, fairly dire straits, Medicare, Medi-Cal, and a letter that says you should be in a nursing home. But instead of using this patchwork quilt of Medicare, Medi-Cal, in-home support services, all this stuff, there's an option to jump onto the PACE program. And the PACE program is supposed to be all-inclusive, whether you need just a little help at the house or you need full-blown skilled nursing. You have to use the doctors through the PACE program, so you can't pick your doctors or bring your doctors over from Kaiser or John Muir. But this is basically what the government's doing is saying, hey, if someone's on Medicare and they're on Medi-Cal and a doctor wrote a letter they should be in a nursing home, that means they're in dire straits medically and financially. And the whole point of PACE is to try to keep people out of nursing homes. And the phrase aging in place is the big buzzword among policymakers to help elderly folks live at home as best they can. And so basically what happens is Medicare and Medi-Cal pay their premiums directly to PACE. PACE gets a flat fee each month for every PACE applicant, and then they provide services. And so the way this might balance out is it's like when you charge a flat fee. Some clients are going to tax you a little bit more. Other clients, man, I came out ahead on that flat fee. So basically PACE gets a flat fee for providing medical services through Medicare and Medi-Cal. And that had been slowly opening up by zip code in Contra Costa County. And I'm pretty sure the PACE program applies to all the zip codes at this point. Don't quote me on that. But the PACE program, they have a facility in Concord. I think it's open to all zip codes certainly in Contra Costa County. But this is another sort of trial program that is being slowly rolled out. It just happens to be that Contra Costa County is basically a full-fledged PACE county at this point. So that's something that, it'll be interesting to see. Right now we have this gigantic budget surplus. And so budgeting is not going to be an issue. As interest rates goes up and the stock market goes down and the capital gains that fuel a lot of California's tax receipts go down, it'll be interesting to see if the promise of PACE can be delivered with the budgets that are given to PACE. I think the heart is in the right place with the PACE program. It'll just be interesting to see how that all works out. Then lastly, the IHSS, in-home support services. That's for someone who's at home, they're on Medi-Cal, and they need someone to help out at the house. The great news on PACE or on IHSS is, it would help someone, get to the grocery store and clean up the house and cook and all these different things. The not so great part of it is Medi-Cal pays, I think it's $16 an hour in Contra Costa County. And if you just drive by McDonald's or Chick-fil-A, you can make $18 or $20 an hour at fast food. And so it's very difficult to get non-family members to participate in the IHSS program. But that's a whole separate Medi-Cal program. that sometimes is the right fit for people as things go forward. Any questions about Medi-Cal, the benefits program, stuff like that? All right. So the big change coming down the pipe for Medi-Cal is the eligibility. And as long as I've been a lawyer, it's always been a $2,000 limit. You have to have $2,000 in cash or less in order to qualify for benefits. And there's exemptions, the house and IRA accounts. But you had to get just down to almost nothing in order to qualify for Medi-Cal. So the big change is that July 1st, they're going to change the resource limit for an individual from $2,000 up to $130,000. And so they got, the state coordinated with the federal government to make this happen. So this is definitely a Democratic administration goal, is to provide more eligibility for Medi-Cal services. Bottom line, depending on how things go with politics, this waiver may be granted again and again. It may not. Who knows? But for the time being, we are going from a $2,000 limit up to a $130,000 limit for an individual. So what that means, it's going to grossly broaden people who are eligible for Medi-Cal services. And by the time you take out the house, which is an exempt asset, and the retirement accounts, which are exempt assets, a lot of Californians, and even very well-to-do Californians, just don't have 130,000 in countable assets. And so that's going to really broaden the number of people who may be eligible for in-home support services, PACE, for even people who are not going into nursing homes. Additionally, the Community Spouse Resource Allowance, the CSRA, that goes up every year. It's 137,000, just over 137,000 this year. So bottom line, for a married couple, if one of them needs Medi-Cal, you can have over $260,000 in countable assets. And again, that does not include the house or retirement account. And so bottom line, the goal here in California, at least from a policy perspective, is, you may have paid attention, they tried to push through some legislators tried to push through single payer healthcare. The hang up was that I think they had to increase taxes by $400 billion. And it was a non-starter among the moderates. And so single payer healthcare did not get off the ground. However, that's what they use in Canada. They have a value-added tax. That's how they fund it. Even the moderate Democrats just can't figure out how to do a single payer just for the state. But bottom line, that went down in flames earlier in the year. So the new buzzword among the policymakers is universal coverage. So what universal coverage means is that using the programs we have, Medicare, Medi-Cal, private insurance, out-of-pocket expenses, broadening those programs to ensure that people get the care that they need. And apparently one of the things they could do to increase universal coverage was to grossly broaden the financial threshold for people to become eligible. And then last but not least, I always put this in there. Some people get concerned, if I got, Social Security, say I got a CalPERS pension, I got $8,000 a month in a pension coming in, it'd be wonderful. Just because you're over that $2,000 or what will be $130,000 some point in the month, that's okay. You only have to be under that threshold limit one day of the month. And so whether it's the first day of the month, the last day of the month, someday in the middle, as long as you're under that limit one day of the month, you're good for the whole month. And so, the bottom line is that come July 1st, there's going to be a big broadening of eligibility. And, what's coming down the pipe is the state has an intention to eliminate the financial requirements, period. So the goal, they said, not until I think it's 2024, not before then, will they eliminate the financial requirements. But perhaps after 2024, they may try to dispense with all financial limit requirements for Medi-Cal eligibility. It would essentially be Medi-Cal for everyone, base no matter how much money you have. And then, if you have your own private insurance, you probably wouldn't use Medi-Cal, but it would cut out all the financial part of the application. That's something that's coming down the pipe. All you can do is plan for what is, and right now what is a $130,000 individual threshold come July 1st. Any questions on the big changes coming up? All right. No Medi-Cal talk is complete without the T chart of exempt and countable assets. If you really want to get into the deep with what different assets are countable and what are exempt, California Code of Regulations, Title 20, the 504 sections. That's where it lists all the assets that are countable and exempt. The big ticket items that are exempt are the residents. You always have to check the box with intent to return, even if there is objectively a no possible chance of returning. You still have to have the intent, the subjective intent to return, and that's what creates the exempt nature of the residents. You get one vehicle is exempt, and all their retirement accounts are exempt. Most people going through the elder law and Medi-Cal process are already getting RMDs, the required minimum distributions, from their IRAs. But every once in a while, you'll have someone who has a stroke in their 60s. They're not quite old enough to get RMDs. In order to create an exempt in order to create an exempt retirement account, it has to be distributing. So even if it's $5 a month, that's important in order to create the exempt nature for the retirement account. Most of the time that's handled because the RMDs are already flying out, but once in a while you'll have someone who doesn't have their RMDs active yet. And so just make sure that that's a good one to be aware of. And the All County Welfare Director letter that goes into that is the 0215. So take a look at that if you're very interested. The countable assets, other real property, stocks and bonds, cash, then the surrender value for your life insurance and annuities. The bottom line is, some people are going to be eligible for Medi-Cal right off the bat. Other people aren't. And so you want to make sure that when you're doing your analysis, is you can categorize the exempt and the countable assets appropriately, so you know whether or not people need to gift or spend down in order to qualify for Medi-Cal. Gifting rules. My favorite part of Medi-Cal is before I even became an attorney, the Deficit Reduction Act was passed. And that was supposed to outlaw gifting in the way that we do it, or stacked gifting is the phrase you'll hear. The Deficit Reduction Act was basically the federal government telling the states, please don't let wealthier people gift their assets away to qualify for a program designed for impoverished people, such as Medi-Cal and Medicaid. All the states were fine with that, but California and a number of what I'll categorize as bluer states have been working on the regulations since 2006. So what that means is the gifting rules from 1990 are still in effect. In the old days, I used to go to seminars in the 2000s that they say, oh, watch out, the DRA is going to be implemented next year. And that's the same thing that they said for several years. And now when people ask, what about the DRA, the Deficit Reduction Act, everyone kind of does a little belly chuckle. Oh. And that's the end of the conversation. So one day, the state may implement the Deficit Reduction Act and the more stringent gifting rules. Until it does, the old gifting rules that you may or may not be familiar with apply. And insofar as the old gifting rules go, the important part to note, one of the first numbers you need to know is the average private pay rate, APPR. Every year, the state, it goes up a little bit. It's the average cost of a nursing home for 1 month. and a welfare director letter pops out each year with the current APPR. And the way that Medi-Cal determines ineligibility based on a gift is they divide the gift by the APPR. So if I make a gift to my daughter of $10,000, they divide that by the APPR, which is 10,933. They say, oh, that 10,000 gift could almost pay for a full month, 0.91 of a month. But the important part here is they drop the decimal. So they drop the 0.91 and you're left with a big 0. So you get 0 months of ineligibility for a $10,000 gift. And then the creative part that California wrote into their laws is gifts only accumulate if given to the same person on the same day from the same account, which means you can give a gift to each of your 3 children of $10,000. Medi-Cal treats that not as a $30,000 gift, but as 3 $10,000 gifts, each one with a 0 penalty. And so what that means is I compare it when I do the consultation, I say it's like dealing cards. You can deal everyone a $10,000 gift on Monday, and then you can give everyone another $10,000 gift on Tuesday. Then you give everyone another $10,000 gift on Thursday. So you can kind of stack these gifts. And even if you gave, $12,000 and you had 1 month of ineligibility, those run concurrently, which means like if you committed, let's say you committed Sorry, everyone. I got a little moment.
There you are.
Here I am. It was a brilliant, it was you missed the best part. Fireworks, all sorts of stuff was going on. Am I back on?
You are. I don't know how you did that, but good job.
I clicked off. Sorry about that. I got a hiccup. So yeah, the bottom line was that, even if you have 1 month of ineligibility, say you gave $12,000 gifts to everyone, that means you have 1 month of ineligibility. But if you gave 5 people $12,000 on Monday, that 1 month of ineligibility runs the 1 month that gave those gifts. So even though you gave 5 gifts, each one causes 1 month of ineligibility. Well, it's just that 1 month. But bottom line, I always use clean numbers. If you wanted to be cute, you could say a $10,932.99 gift. Yeah, you could do that. You'd still be under, but I just use the flat numbers. And if you don't believe any of this is true, you say, what moron would create such a system so easy to evade? MC 176 PI. That is the form that the state uses to calculate ineligibility. And you're not going to find anything in the regulations that say, hey, it's fine to give $10,000 a day per person and cause no ineligibility. But you will be able to see the form that's used. Whenever people ask me, how do you know this works? I say, I have the form that the state uses. That's that MC 176 PI. And if you like looking at it, it's just a little 1-pager. You can literally calculate the penalty for each gift that's given. And the asterisks that I put here, the same person, same day, same account, that's on that form as well. So, bottom line, you're not going to find that in any regulation. You'll see it in the CEB manual. You'll see it in the MC 176, but that's about it. So once you're eligible for Medi-Cal, once you're under that that asset threshold, then the next concern is, well, what's share of cost? So share of cost is kind of the same as it's always been. You take a look at the monthly income, it's pension, Social Security, IRA RMDs, all that sort of stuff. Importantly, investment income does not count. So, you know, if you're earning interest on a savings account, or you have some stocks or bonds, the dividends you earn, those don't count as part of your share of costs. It's only these very regular monthly payments, pension, Social Security, IRA RMDs. Sometimes people take that out at one time during the year. You just have to amortize that over the course of 12 months. And that's how you figure out your monthly RMD for an IRA. You subtract the monthly premium for healthcare insurance. You know, that's often baked into the pie with Medicare. That's already taken out from the Social Security. Sometimes people will have supplemental healthcare insurance. You can deduct that. There's no reason to give up your supplemental healthcare insurance because basically Medi-Cal deducts the amount that you have to pay to the supplemental healthcare people from the share of cost. And then you have a $35 personal needs allowance. So basically the entire set of income goes to the share of cost for an unmarried applicant. And some people will say, well, how do I pay my property tax? And how do I pay the PG&E for the house that I've left? You say, you know, the beneficiaries of your estate need to figure out how to chip in for little things like that. Because Medi-Cal is going to go after most all of the income that's coming in each month. And then importantly, this share of cost, this is specifically for a long-term care scenario. Yeah, there's a different share of cost for in-home support services. But frankly, we just don't have enough time to kind of go over that as well. But for long-term care, skilled nursing facility, Medi-Cal, that's your share of cost calculation. You know, for a married couple, it's a little bit different. The MIMNA, minimum monthly maintenance needs allowance. Sorry, I forgot needs in there. But the MIMNA, each year, again, the All County Welfare Director letter comes out and tells you what the MIMNA is. And for this year, it's a little over $3,400 a month. So a lot of people get confused about how to calculate the MIMNA. Some people go, hey, the healthy spouse gets to keep $3,435. And it's a little bit more detailed than that. You know, but I think the easiest way to think about this is you always ask, does the well spouse have personal income of $3,435 a month or more? And if they do have that amount, they get to keep that amount. So Medi-Cal is never going to go after the healthy spouse's income. They're only after the sick spouse's income. So if the well spouse's income is over that $3,435, well, then all of the ill spouse's monthly income is going to go to share of costs. And then the well spouse gets to keep her or his, or, you know, they get to keep their entire income. If the person has less, if the well spouse has less than $3,435 coming in a month, then the well spouse can borrow from the ill spouse's income up to that amount until they top off. So say someone's earning, you know, $3,000 in Social Security, and that's it. And then their spouse is earning, you know, $2,000. The well spouse who's earning $3,000 can borrow $300 or $435 a month, so they top off up to that minimum allowance each month. So they can borrow that from the sick spouse's income, and then that's the sick spouse's share of cost is reduced by that amount. So bottom line, the well spouse is never going to have less than $3,435. You know, they're going to have their own income, and then they can supplement with the spouse, the sick spouse's income up to that limit. You know, theoretically, if two people each have $1,000 in Social Security and that's it, well then, yeah, then the well spouse keeps the $1,000 and they get to borrow all of the $1,000 from the sick spouse. You'd have a zero share of cost. and they'd have 2,000 in income, which is what they've been living on. But that's oftentimes something that can throw people for a loop with all, numbers and all county welfare director letters. Any general questions? All right. So if you think of Medi-Cal in sort of 3 chapters, there's eligibility. I'm getting unstable again. Sorry, there we go. There's eligibility, which is the assets. There's share of cost, which is income, and then there's recovery. Recovery, since 2017, recovery is only an issue on estates that go through a formal probate. So the bottom line is if you have a standard living trust, that protects you from a Medi-Cal recovery. It's got to be properly funded and that sort of thing. And I always think of it, it's like a bear trap. If you go into the program, your house is exempt, your IRA accounts are exempt, that's great, but they're still in your name. And if you don't have a living trust to protect the house, or you don't have beneficiaries filled out on your IRAs to direct those, well, guess what happens? They can go through a formal probate. I think the formal probate, if you're over $184,000 now. So a lot of, certainly a house that in the Bay Area, that's going to go over 184. And for a lot of IRA accounts and 401ks, those will be over 184,000. So bottom line, you want to make sure that you get into the program, but you want to make sure that you get out of the program unscathed as well. And the easiest way to do that is with a living trust for the house that's exempt going into the program, but not exempt if you have to get out through a probate. So use your living trust to protect the house. And then, and it's better to keep the house in the elder's name because you get the step up. So you don't just go, oh, just gift the house and be done with it. Well, yeah, you gift the house, but then you gift the cost basis as well. So generally speaking, you want to keep the residence in the elder's name in trust, and then you get your step up, which is good for taxes. You also you avoid probate, which is good for avoiding recovery. And same thing with your IRA accounts. They're exempt going in, but if you end up in a probate, a formal probate, as I'm sure everyone's aware, one of the requirements is that you send a letter up to Medi-Cal and say, hey, we're in a formal probate. Would you like us to pay you back? And the government works really slow on a lot of things. Probate recovery letters, those get cranked out pretty quickly and are sent into the court. I've never had Medi-Cal drop the ball on one of those. So it's one of those things where good planning can get you into the Medi-Cal program and get the family out of the program relatively unscathed. So as a general rule, you don't have to be too creative with recovery avoidance. Yeah, so just, basic information. Canner, C-A-N-H-R, they are the go-to organization for Medi-Cal information. I go to the seminars not each year, but I try to go to the seminars every other year or so. But yeah, they're the ones who, let's just say, they inspired many of the slides here. And Canner's an excellent resource. You can literally call them with a question, and they have staff who will usually work with you on very specific things, specific questions, that sort of thing. A lot of time you're with Medi-Cal and elder law work, you don't really have even legal questions. You just have, this nursing home's giving me a hard time, or, they're trying to kick me out, that sort of stuff. And Canner's an excellent resource. And if you would like to sort of develop an elder law practice, I'd say the first stop is the Monterey seminar. They usually do them right before Thanksgiving. They did an early one this year because they were doing the big change in July. So they just had the one in April. But yeah, Canner is by far the most, or by far the best source for Medi-Cal information, legal, financial, or just general administrative questions. Code of regulations, that's where all the Medi-Cal rules are. It's on the internet. If you look hard enough, you can find them. But it's a big, thick tome. So, I try to pepper a couple of the slides with the different regulations in there. I might have put Title 20 in there. It's Title 22. Sorry about that. So California Code of Regulations, that's all the regulations about Medi-Cal. And then the county welfare director letters, each year there's probably 15, 20, 30 director letters. A handful of them are pertinent to Medi-Cal planning, at least from the lawyer's perspective. But the big ones are certainly they'll let you know what the MIMNA is, the minimum maintenance monthly needs allowance each year. And they'll also let you know what the APPR is. That's what's important for gifting, average private pay rate. They let you know, they just update those each year. It's just good to know. And certainly there's a list serve at Canner, and they just send out, when those letters come out, they just say, hey, everyone, the letter came out. And then, you print it out and you have it for the year. But, those are, I'd say, the primary spots where I go when I have questions about, Medi-Cal and what to take a look at and how to research your way through things. Yeah, so that's the slideshow, if you will. Yeah, I got a couple minutes early. I always try to leave quite a few minutes just for questions, because a lot of the time people show up because there's something hot on their plate, or they just have a question that's just kind of bugging them. And so certainly if you have questions, fire them away.
Brian, you could go ahead and stop sharing, and then everybody can see each other and ask questions if they want.
There we go.
Let's get you, let's see. Anybody?
It doesn't let us start the video.
It should.
All right, I'll try this. Oh, there it is.
All right, you got a question, Rita?
No.
No, okay. Well, it's good to see everyone.
Yeah.
Sort of.
Yeah, certainly, if there aren't any questions, that's fine. But yeah, and bottom line, if you have a quick question or something, always feel free to just give me a jingle or an email. I try. I'm not perfect in my responses, but bottom line, if you have a quick question, I'm not looking to make a profit off a quick Medi-Cal question here and there. So yeah, do feel free to just give me a call. And a lot of time I'll just say, hey, this is what I did in the past. There's not like a rule that says it's okay, but it worked. And that's for a lot of Medi-Cal and just administrative law type of issues. That's been helpful just to sort of see what has worked in the past. But yeah.